Bruhn, we welcome you to our meeting this afternoon, and you may begin your opening statement.
Good afternoon. Thank you very much, Justice Wiggins and members of the Commission. I hope you all had an enjoyable lunch. I can tell you I did not for some reason. And if my wife were here, she'd tell you that's very unusual for me. But let me begin by thanking all of you for your service in this process. As an attorney, it's greatly appreciated. And I'd like to tell you, as I sit here today, I have the same level of pride and enthusiasm as I felt driving home in 1980 after I was sworn in to be an attorney. I never dreamed as a poor young river kid that I'd even go to college, let alone be sitting here in the Supreme Courtroom seeking this nomination. I'm proud to be an attorney in Iowa, and I've been an attorney for a little over 30 years. And I can tell you at the outset that I will fulfill my role as a justice with great honor and respect if appointed, and with great understanding of being a public servant to the citizens of Iowa. You have my resume and application information, and in the interest of not repeating much of the biographical and educational information, I'll try to cover what I believe to be the most salient points relative to serving as a justice. Those points can be broken down into four categories: family, experience, judicial, ideology and philosophy, and work ethic. As always in my life, family comes first. I'm a lifelong Iowa resident, and I grew up on the Mississippi River in Clinton, only leaving to get my education. I met my wife, Debbie, while I was attending law school between my second and third years of law school while I was home clerking. And I can say that I've had the most incredible and daunting task has not been in my legal profession, but it's been being a parent and raising two boys. My wife and I raised Chris, who's now 26, and Brandon, now 24. Both of them have chosen thus far to pursue careers in engineering. Our families have both resided in the Clinton area, and this has been a blessing for us. We've had the great family support during our family life and careers. Let's focus on my professional experience. I bring over 30 years of very broad and diversified general practice experience. I've been involved in simple legal matters. I've been involved in complex legal matters. I have extensive trial experience in state and federal courts, both in Iowa and Illinois, as well as appellate court experience. I've handled appellate court cases, mostly in Iowa, but also in Illinois and in the Eighth Circuit. I have practiced in about every area of law you can think of. I do not have any typical clients. My clients have included the poor, the rich, the young, the old, the disabled, minorities, farmers, small businesses, large businesses, corporations, cities, school boards, and other civic organizations. My practice areas have encompassed juvenile, domestic, criminal. I've been engaged in civil litigation of all sorts, personal injury, products liability, various negligent types of cases. I've been engaged in wills and trusts, real estate, probate, tax issues, corporate matters, school law, condemnations, proceedings, municipal law, and I'm sure there's other areas that I've left out. In my judgment, it's this depth and quality and breadth of experience that sets me apart from the field of candidates, together with having an excellent understanding of trial court practicalities and judicial operations. I think it's pertinent to note that my trial experience has not been focused in just one particular area. I've been sort of a lunchbox attorney when it comes to trial experience. In addition, I spent 9 years serving the Clinton Community School District as a school board member, which I believe has afforded me valuable experience that would be useful as an appellate court judge. I had to learn to listen to public input on issues. We had to, as a school board, deal with administrative and budget issues. And in my view, I kind of analogize that to being a judge. And that experience gave me some useful input outside the arena of being an attorney. As I said, it's this foregoing experience, professional maturity, and varied life experiences that I feel qualify me to be a judge and distinguish my qualifications. I'd like to focus a few thoughts on judicial ideology and philosophy, and I'd like to say at the outset, I understand this is not a political process. My comments are not political in nature, but I think it's important to hear my view with respect to judicial philosophy. On the issue of judicial philosophy, it is fundamental that in upholding the oath of office to enforce the Constitution, that judges do act with restraint and that they do not cross over into legislative functions. I think most people would agree judges should not make policy decisions that are left by the Constitution to the legislature, just as the legislature may not pass laws which violate the Constitution. In my view, the original intent and meaning of the Iowa and U.S. Constitutions as fixed by our founding fathers and subsequently amended apply just as well today as they did when written. If I were a judge, I would interpret and apply the law in accordance with the text as written. The words have the same meaning today as they did 200 years ago. I don't subscribe to the philosophy that the Constitution needs to bend, float, or be adjusted to fit the times. In my judgment, if you get into that arena, then you start jeopardize crossing into usurpation of legislative functions. As a judge, I would keep in mind that it's not the function of the court to rewrite the Constitution through decisional policy making, but it's the function of the court to uphold the Constitution. I seek this position with no hidden agendas or platforms. I really do love the law. I do love debating issues. I love analyzing, resolving conflict, working and talking with people. I respect dissent without becoming personally involved or personally reactive, and I think that's very important on a multi-member appellate court. And I appreciate hard work and the rewards that come from it. As I said, I'm not a politician, but I do have some commitments if chosen as a judge, which I'd like to share with you. If nominated and appointed, I will be committed to confronting every case with an open mind, to fully and fairly analyze all legal arguments that are presented. I would be respectful and open to all the views of my colleagues and assure that decisions are based on the law, not personal opinions, the latest public opinion poll, or extraneous factors that don't belong in the court system. I can assure you I would not interject my personal opinions into court decisions. I also feel I'd be very capable and willing to improve the court's outreach and image within and without the judiciary. I feel that's something that needs to be done, and that's something that's extremely important at this particular point in time. My other commitments include being an impartial advocate of the law, prompt attention to cases assigned, and I would strive to get decisions out promptly. I believe I would be capable of writing understandable opinions which are legally sound, but in plain language for all to read and understand, and written in rule-like form. I would be an advocate of respecting judicial restraint while still protecting constitutional rights, understanding the limited role of the judiciary. I would apply stare decisis with respect for prior scholarly analysis, with the understanding that the law is not stagnant or cast in stone. It's important courts operate in a system of precedent, which has been shaped by other judges who have been equally striving to live up to their judicial oath. It's important so that we have consistency in the law. It's important so that we have law that people can rely on. I would also be willing to reach out to district court judges and judiciary employees. I would seek and welcome feedback with respect to administrative matters. I would give serious consideration to advisory committees, to the judiciary, and respond to their recommendations even if they're not adopted. I also would be willing to reach out to the public, educate the public on the judicial process, and make the court more transparent to improve not only the confidence in the court, but to give the public a better understanding of the role of the judiciary. And maybe most importantly, I would respect all persons in all branches of government. Lastly, on work ethic, if you review my application, beginning as a teenager and young man, I held a variety of jobs. Some of them were interesting and fun, and some of them were downright dirty and horrible. And I think that's important to keep in mind when looking at the background of candidates. Also, with respect to my professional practice, I don't have a typical day. I've had to switch gears all the time. Every day something is different, and I've had to switch gears to get the job done, working irregular hours, long hours, doing whatever it takes. Despite that, I've been able to maintain a good balance between my work life and my family life. This will probably be my one and only opportunity in my career at my stage to pursue this. There can be no other or higher calling for a lawyer than to serve on the Supreme Court. This is not something that I've taken lightly. It's not something that I'm pursuing out of perception, prestige, or notoriety. It's something that I really would enjoy doing. I would love to serve the citizens of Iowa, and I would love to serve the law and be a loyal advocate to the law. Thank you, and then I'll look forward to any questions you may have.
Well, I'm going to start. You brought up original intent and the Iowa and the federal Constitution. They were drafted in very different times. The Iowa Constitution was drafted at a time when there was distrust in government. It meant to preserve people's rights more so than the federal Constitution. But some of the language of the federal and the state constitutions is the same. How do you see, just following the standard language in the Constitution, when you have to look at the convention and figure out the intent of the Iowa Constitution from the Constitutional Convention rather than just the plain language of the Constitution?
Well, when you have a constitutional issue, I think you have to look at the plain language as it applies to the factual situation at hand. That is not to say that you have a result-oriented policy that you fit into the constitutional language. Rather, you look at the literal language of the Constitution, and taking the facts at hand, you make a call as to whether or not the legislative action fits within the constitutional norms, and whether Iowa constitutional law should mirror federal constitutional law exactly. I think that's a question open for debate. It's a question, historically Iowa law has pretty much been decided along federal constitutional standards, and there could be circumstances which would arise that would deviate from that practice in establishing a body or principle of constitutional law under the Iowa Constitution. My view is that if given the three separate branches, there should be initially rebuttable presumption or deference to legislative action, and if an issue is clearly unconstitutional, it's the duty of the court to declare it so. If it's reasonably debatable, it may be the duty of the court under our system of law to defer to the legislature.
Any other questions on this? Mr. Pace?
Thank you, Justice Wiggins. Good afternoon. I heard you talk about stare decisis and how precedent was important and that should be employed. Can you speak to that for a minute as to how the concept of stare decisis would be employed, and as specifically as it relates to prior interpretations of the Constitution or prior interpretations of statutes, how those things fit together?
Well, stare decisis plays a very important role, in my view, in establishing constitutional law, because you have a set of prior precedents that have been analyzed and well thought out by prior judges, and in my view, there should be a rebuttable presumption that their decisions are correct. And under the principle of stare decisis, cases should not routinely or easily be overlooked or overturned. But I'm not a believer that the law is forever cast in stone, that it's stagnant, and I can't come up with a specific example in a vacuum, but there may be situations that arise over time where that prior decision is no longer correct under evolving law, and there may be times when it is appropriate to overrule precedent. But I believe you have to have the humility to give prior appellate court justices the benefit of the doubt that their decisions are well thought out and they're correct. I believe all justices take the bench with the notion of trying to determine what the law is and to uphold the Constitution. So it's something very important not to easily overlook.
Any other questions to my right? How about to my left?
Hi, Mr. Bruhn.
Good afternoon.
You mentioned in your presentation as well as in your application, you're talking about improving communication with judges and the general public. How would you go about doing that?
It's a very good question, and it's something that's very appropriate, because if there's any weakness right now that I see with the Supreme Court, it's perception in the eyes of both our judiciary and the public. And I see some action being taken already by discussions about holding oral arguments throughout the state. Public speaking would be one way to educate the public with respect to the role of the judiciary. Getting into schools, encouraging civics programs for our youth. I think we need to readdress that maybe in our high schools curriculum. Also, on a judicial level, I have talked with many judges and judiciary employees who feel there needs to be who feel there is a disconnect and there needs to be a reconnect and some lines of communication open. If I've heard any criticism, it's been, we make recommendations on an advisory committee, but we never hear back, that sort of thing. So I think opening up the lines of communication and having a collaborative effort between the judges on a district court level and court employees and the clerks and listening to them and having an open dialogue back and forth.
Would you continue, you're in a number of associations and organizations. Would you maintain your membership in that?
It depends on what the organizations are. If they're, I'm a member of Rotary, for example. I do not find that to be an organization that would be impermissible for a judge to belong to. As long as it's an organization that doesn't, I don't believe I'm in any discriminatory organizations, but of course, judges have to be neutral and they can't belong to organizations that take political positions, or they should not take a management role in organizations. But I believe, again, that's part of the outreach of justices. They shouldn't. They need to be more visible in the public, and the public needs to see me out at Rotary, and to see me in my community, and to see me out in Des Moines, and know who I am and what I'm about.
Thank you.
Mr. Brody.
Good afternoon. Noted in your material that you served nearly 10 years on the Clinton Board of Education, including a stint as the president. From my perspective, that's probably ground zero for some of the more controversial or challenging aspects of public service. Can you describe or provide some specific examples of a challenging issue that you needed to address, and how would your colleagues at that time on the Board of Education viewed your engagement with them on that issue?
Well, early on in my tenure on the school board, we had a superintendent who was an excellent administrator, but he was not very popular with the community, in part because of his decisions, and in part because he was all business and didn't have the human relations skills maybe that he needed. And I liked the administrator because he knew what he was doing, and one of the hardest things I had to do was call him in and tell him what my personal views were with respect to his lack of human resource skills, so to speak. That was not a comfortable situation. We also had a very popular employee who was being terminated, and it created quite an uproar. And as a board, you know, we would hear appeals on terminations, and upholding our responsibility in that setting versus responding to public opinions was challenging.
Any other questions? Mr. Cook?
Sir, you cite in your materials a quote from U.S. Supreme Court Justice Samuel Alito. What do you believe would be your most important contribution to the court if you were chosen?
Number one, my depth, breadth, and quality of trial experience. Number two, my ability to communicate on a personal level with people from all walks of life. Number three, my ability to relate to the average Iowan. I've lived in Iowa 55 years, and I bring traditional rural Iowa values and experiences to the court, and I think I can relate to everybody. And I think we have in that regard, I believe the diversity in our state is greater than a lot of people realize, and I believe I can relate to people of all diverse backgrounds and ethnicities.
Thank you.
I just have one short question. Are there any cases that this court has decided at the constitutional level dealing with the Iowa Constitution that you disagree with?
That's a difficult question for me to answer at this point because I didn't really review constitutional cases, but to give you an honest answer, I'm sure there are, but I can't point to one off the top of my head.
Thank you. Thank you very much, and we really appreciate your putting your application in, and I wish you good luck.
Thank you.
Thank you.